Good morning. Welcome to American Government. Today we're talking about Wilson's Chapter 16, which covers the judiciary. Constitution talks about the judiciary in Article 3, a number of sections there. For the first article, the Constitution is about the legislative branch. Second article about the presidency. Third article is about the judicial branch. These are the three branches of the federal government in the United States. Article 3, Section 1 says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So one Supreme Court will hear cases related to the United States. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. That means that judges appointed to the Supreme Court are appointed for life. They can be impeached if their good behavior is not good, under the same rules that a president or vice president can be impeached. That is bribery, treason, high crimes, and misdemeanors. There have been a number of federal judges, no Supreme Court judges, but a number of federal judges at the lower levels who have been impeached and convicted of bribery for the most case, and have been removed from office over the last couple hundred years. Article 3, Section 2 continues that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Right? So that means that anything that's under the Constitution, United States law, federal law, or treaties which are made only by the federal government that have been made or will be made in the future. This is the power that the Supreme Court has. It will deal with controversies to which the United States shall be a party. It can deal with controversies between two or more states. It can deal with controversies between a state and citizens of another state, or between citizens of different states. So it means the Supreme Court deals with interstate issues or anything related to the federal government, federal laws, and things that affect more than one state. The Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as Congress shall make, meaning that the Supreme Court is an appeals court. The Supreme Court is not the place one goes to file a federal court case. You go to a federal district court. The district court will make a decision that can be appealed to a federal appeals court, and then the Supreme Court may or may not hear a decision from an appeals court. The Supreme Court justices decide which cases they will hear each year. They meet from October into May as their session. They hear during that period a number of cases, roughly around 100 or so, and sometimes emergency cases, and then they deliberate, and then they come back later and they announce their decisions on these cases during the summer after each session. There are constitutional limits on the federal judiciary. Remember that we have here a constitution which divides power between three branches of government and establishes checks and balances so that each branch of the government is checked in some ways by the other two. For the judiciary, those checks come mostly from Congress. That is, the Congress can create such inferior courts. That's like the Court of Appeals, the federal district courts, that it decides to establish. The Supreme Court can't decide on its own what courts to establish. It also says that under regulations such as Congress shall make, meaning that Congress can come up with rules about the behavior of the federal court system. Cases that are limited to one state, and this is generally criminal cases, other cases that oftentimes are only within a state, those don't go to the Supreme Court. Those will go to a state Supreme Court for decision. Sometimes cases decided by state Supreme Courts may end up in the federal system as well. But criminal cases generally not. The Supreme Court may only get involved, generally gets involved only in criminal cases when it deals with the death penalty. Article 2, Section 2 of the Constitution says that the president and congressional power over appointments to the Supreme Court are established in the Constitution. That is, the president shall have power by and with the advice and consent of the Senate to appoint judges to the Supreme Court. So the Supreme Court can't appoint its own judges. The people can't appoint their judges to the Supreme Court either. They're not elected positions. They're appointed by the president, which has to get Senate approval for their term to take effect. Now, keep in mind over the last few years, in the last year and a half of the Obama administration, a Supreme Court vacancy came open. Obama followed his constitutional obligation and named a successor, Merrick Garland, to be the next Supreme Court justice. The Senate at the time was controlled by Republicans, and the majority leader, Mitch McConnell, said that the Senate would not consider an appointment to the Supreme Court in the last year of a presidential term because elections were coming up, and so let the people decide who they wanted. And so in 2016, there was an election. Donald Trump won the election because of the Electoral College, and so he nominated the successor instead of Barack Obama, even though the Constitution said the sitting president at the time the vacancy comes open would be the one to name the successor. He got then his own choice. Donald Trump went on to appoint 2 more people to the Supreme Court. So 3 of the 9 Supreme Court justices are appointees of Donald Trump at this time. This is how the federal court system is arranged. You see here on the left here, down at the bottom, you got U.S. federal district courts, which is the first level of the federal judicial system. There are 94 district courts spread out all over the United States. They're located in major cities, even state capitals, places like that. And they deal with these kind of cases. If you have a federal court case you want to deal with, it goes to the federal district court. Those cases can be decided at the federal district court if both sides or accept the decision. That's as far as it goes. If one doesn't accept the decision, they can appeal to a U.S. Federal Court of Appeals. There are 13 of these spread out over the country, and so the federal courts of appeals generally deal with multiple states, multiple cities. And so you got 13 of those, 94 of the district courts, so they're sort of spread out between those. If a case gets through the Federal Court of Appeals, then it can be appealed to the Supreme Court as well. The Supreme Court, as I mentioned, gets to decide whether or not it hears these cases. It can simply say, we're not going to do anything, going to let it stand. The Supreme Court also will hear other kinds of cases occasionally. That is, state courts here in the middle here, you get a local trial court, make a decision that goes to a state appeals court, again, similar to the federal system, and then it will go to the highest state court of appeals, usually called the state Supreme Court. Those cases might end up in the Supreme Court. Supreme Court can decide whether to take them. Generally, what the criteria is for the Supreme Court to decide to take a case is, does it have some relevance to interpretation of the Constitution? The Supreme Court can also hear these kinds of special courts: the Court of International Trade, the Court of Claims, the Court of Military Appeals. So these are 3 specialized courts that are not under the jurisdiction of either states or federal district courts. They have their own systems where they hear specialized courts cases dealing with international trade. The Court of Claims has to do with the claims of property, mostly on abandoned ships found at sea. The Court of Military Appeals has to do with appeals from the military courts of justice, that here, courts martial. Okay, these are the 13 districts, as you can see. District 1, 2, 3 are up in the northeastern part of the US. District 4 deals with basically the mid-Atlantic there. District 5 is Texas, Louisiana, Mississippi. 6 is the kind of Midwest there. 7, Midwest. 8, Upper Midwest. 9 is California, Oregon, Washington. 10 is the Rocky Mountain area. 11 is Georgia, Alabama, Florida. And then there's a federal appeals court in DC. There's also a federal appeals court, which is separate from these other ones. The Virgin Islands fall into District 3, Puerto Rico falls into District 1, Alaska and Hawaii fall into District 9. Now, the federal courts of appeals are appointed in part by advice from the local senators and congress people of those states that lie in those districts. And you notice the appeals districts coincide with state boundaries. And so the general practice is that when a president is to appoint a new judge to a federal court of appeals, the president will ask the local congressmen and senators for their advice on their chosen nominees. What this means then, if they follow that advice, that means then that you tend to get appeals courts that have a more liberal bias towards them in liberal states, such as districts 1, 2, to some extent 3. In districts like District 5 or 11 or 10 or 8, you get more conservative judges on those courts of appeals. 9 tends to be a fairly liberal one. And so what happens oftentimes is that the Supreme Court will let decisions made by an appeals court they agree with politically to stand, but might hear cases that come out of an appeals court they disagree with politically, and so they can have the chance to overturn that appeals court. There is politics involved in the Supreme Court, a lot of politics. Supreme Court of the United States, according to the book, it goes through three major kinds of periods in terms of the kinds of court cases they heard. From the beginning, 1787, up until the end of the Civil War, basically you have the Supreme Court dealing with stuff related to the building of a nation, the legitimacy of the federal government and its actions, i.e., can the federal government tax people? Can the federal government create a national bank? Can the federal government do this or that kind of a thing? Or these things powers that belong to the states? One of the most famous Supreme Court justices during this period was John Marshall, who was the Chief Justice of the Supreme Court for 34 years, from 1801 to 35. And so he had a huge effect on that. And Roger Taney came in and had control over most of the rest of the period. So really have only two Supreme Court Chief Justices during that period. After the Civil War, you get the beginnings of industrialization in the United States, a lot of economic expansion, and the court tends to focus more and more on things related to the relationship between government and the economy. Can the government tax things? Can the government regulate trade? Can the government regulate such things as the fares determined by railroads? Railroads run across multiple states. So does that mean that they fall under the jurisdiction of the federal government, or do they fall under the jurisdiction of each state in which they operate? Cases like that. Salmon Chase and Charles Evans Hughes were the two major Chief Justices during this period. From 1938, now this is the end of the New Deal. Keep in mind here that one of the things that happens is that up until 1937, the Supreme Court tended to be dominated by fairly conservative justices. Each president would not necessarily have a chance to appoint justices. Some presidents would, and so it was just coincidence whether it was a Republican or a Democratic president, a conservative or a liberal, who appointed the justices. And so the Supreme Court's political nature changed over time. And when Franklin Roosevelt came into office in 1932, he had a very big majority in the House and the Senate, Democratic majority in both those houses, in Congress, as well as himself. Most of the state's governors were also Democrats after 1932, but the Supreme Court was still dominated by people who'd been appointed by the conservative presidents of the 1920s. And so initially, Roosevelt's New Deal met with a lot of resistance from the Supreme Court. After 1936, when he was reelected, he came up with a plan to increase the size of the Supreme Court, to add more justices, thinking that that would be a way for him to appoint liberal justices who would agree with the New Deal and support it. It became a kind of a scandal, and he backed down from it. But it did, I think, lead the Supreme Court to become more in tune with what was going on in the country, because people suffering from the Depression wanted the New Deal programs to work. And the Supreme Court began to change its views on some of those, and they let some of the New Deal programs go through. Some of them had been revised from earlier programs, and so they got through this time, and so they went into effect. But Franklin Roosevelt was in office from 1933 till 1945 when he passed away, 12 years. That means he got to appoint a lot of Supreme Court justices. By the time he passed away, all 9 of the Supreme Court justices had been appointed by Franklin Roosevelt. They continued because they're appointed for life, and so they continued to shape the Supreme Court after Roosevelt had passed away. So the cases that came up about civil rights and other kinds of things in the 1950s and 60s were heard now by a liberal Supreme Court. Keep in mind the 1896 Supreme Court decision, Plessy v. Ferguson, which was a conservative court that determined that public facilities could be segregated as long as they were equal, separate but equal clause. That was in effect until 1954, when the Earl Warren Court heard the Brown versus Topeka Board of Education case, and that court decided that the separate was inherently unequal and therefore unconstitutional under the 5th and 14th Amendments. That was a liberal Supreme Court that decided that. Now, 70 years later, we've got a conservative Supreme Court once again. 6 conservatives, three liberals on the court. And so a lot of court watchers are wondering what's going to happen to various kind of civil rights decisions and other kinds of things that were decided back in the 60s, 50s, 60s, and 70s. We already have some clue of that, which I'll come back to in a few minutes here. Cases that have decided the Supreme Court are among them things like the early ones that were decided. Marbury versus Madison of 1803 and McCulloch versus Maryland of 1819. These are the kind of things that established that the Supreme Court could declare certain acts of Congress or actions by the president to be unconstitutional, that is, in violation of the Constitution. They also determined in these cases that the clause in Article 1 of the Constitution that says that Congress can make such laws as are necessary and proper for the functioning of the United States was legal and constitutional, and therefore the Congress could pass laws on things that were not specifically mentioned in the Constitution, that there were implied powers in the Constitution. So that allowed the US Constitution to be interpreted and changed and amended, and allowed Congress to go about its business without constantly having to revise the Constitution or amend the Constitution. This has allowed the Constitution to remain in effect for a very long time. The US Constitution is the oldest surviving governing document of any country in the world. It's not usual for countries to follow the same constitution for hundreds of years. Generally, decades is about as long as constitutions survive, because they get revised, governments change, needs change, etc. And sometimes it's a political thing, sometimes it's a legal thing, but constitutions tend to get revised a lot and changed. Other cases, as I mentioned, that were heard by conservative courts, such as the Dred Scott versus Stanford and the Plessy v. Ferguson, were decisions that greatly restricted the rights of African Americans. The Dred Scott case determined that slaves were property for life and that they were not citizens of the United States. Plessy v. Ferguson, as I said, separate but equal facilities were constitutional. Brown versus Topeka Board of Education overturned Plessy. The Roe v. Wade decision, the Supreme Court decided in 1973 that an abortion was a medical decision, and therefore, being a medical decision, it was the business of a woman and a doctor and nobody else's business. And so a woman could have abortions because it was a medical thing, and therefore the rights of privacy meant that there could be no restrictions on them. That has been unchallenged ever since 1973, and states have been able to impose various kinds of restrictions, the most severe of them being the recent decision by the Texas legislature to ban all abortions after the 6th week after the fetus is formed, which is before most women would even know they're pregnant. And so basically, for all intents and purposes, Texas has outlawed abortion. The current conservative Supreme Court has allowed the law to stay in operation while it hears the case. It heard the case recently, but it may be months and months before they announce their decision on this. Obergefell v. Hodges of 2015 was also heard by a conservative Supreme Court, but it did say that same-sex couples have the right to marriage according to the Constitution. The Constitution does not define marriage as being between heterosexual couples. It can, therefore, the right to privacy extends to who gets married. Citizens United versus the Federal Election Committee of 2008 has been one of the most significant court cases heard in recent decades by the Supreme Court. This basically was a case in which corporations and unions claimed they were people, and that under the Constitution, as people, they had the First Amendment guarantees of free speech. And that meant that in this court case, basically what Citizens United said was that corporations, unions, and other political action committees had the right to invest unlimited amounts of money in political campaigns in order to shape the government and elections. It has, frankly, been a disaster for American democracy over the last 14 years because it has led to a flood of money into elections from undisclosed sources. They could be foreign, they could be whatever they are. They don't have to disclose their sources anymore. And you see their ads on television all the time, especially around election time. Right now, there's an ad running out there that's talking about how Americans' freedom depends upon Congress not restricting the price of prescription drugs, under the claim that these are concerned Americans who want to make sure that we get the best medication possible, when actually, well, who's paying for that ad is pharmaceutical companies who want to be able to raise their prices and increase their profits. All right, the Supreme Court. Let's take a look at who the Supreme Court is. You've got these 9 people. John Roberts is the Chief Justice of the Supreme Court. He was appointed by George W. Bush. Samuel Alito, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett are also justices appointed by Republican presidents. They are varying in their political perspective. The most conservative of all these is probably Clarence Thomas, with Samuel Alito and Amy Coney Barrett probably being the 3 most conservative of these justices. Roberts, Kavanaugh, and Gorsuch kind of tend towards a middle thing, and sometimes they'll agree with the 3 appointed by the Democrats, sometimes they won't. And they're kind of the swivel point here. Now, John Roberts, as Chief Justice, seems to be very concerned about the reputation he will have going down in history. And so he seems to be a man who wants to make decisions that will make him look good for the future, frankly. So he's not willing to go with either the far right or the far left on most decisions. 3 nominated by the Democrats: Stephen Breyer, Elena Kagan, Sonia Sotomayor. Breyer is the oldest one on the court, and he's at retirement age, and there has been pressure on him to retire now before the midterm elections, because the fear among liberals is that in 2022, that the Senate might get control of the Republicans might get control of the Senate again in 2022, which would mean then that if Breyer leaves office, then Joe Biden would not be able to get a liberal nominee through a Republican-controlled Senate, and they would control it, and they'd simply refuse to hear any nominees until 2024, with the hope that you'd get a Republican president in power, and they could cement their majority, and therefore they could get a 7th conservative onto the Supreme Court. Okay. Think a bit about the justices overall. This is about since the founding of the Republic and since the creation of the Supreme Court, there have been now 115 people who have served on the Supreme Court. 110 of those male, 5 of them female. Sandra Day O'Connor was the first female. She was appointed by Ronald Reagan back in the 1980s. 3 of the other 4 are on the court right now. Ruth Bader Ginsburg was the 5th woman who served on the Supreme Court. 112 of these Supreme Court justices have been white. And 2 African Americans. Thurgood Marshall was the first one. It was appointed by Eisenhower back in the 50s. And there's been 1 Latina, Sonia Sotomayor, who is still on the Supreme Court. 91 of these were Protestant in religion, 14 of them Catholic, 8 of them Jewish. In terms of their education, take a look at this. 49, that is a little bit less than half of them have had law degrees. You do not have to have a law degree to be a Supreme Court justice. There's nothing in the Constitution that actually says anything about the qualifications for a Supreme Court justice. No age requirements, no citizenship requirements, no requirement of being a lawyer, having a law degree, having any prior experience. And so anybody can be on the Supreme Court. You could be appointed to the Supreme Court if you had the right connection. 18 of these justices have had some law education, but don't have a JD degree. That is, these are people who basically got law education before there was such a thing as a JD degree, a Juris Doctorate. Those are people who were in the late 18th, early 19th century, basically. 47 of the justices, almost the same number, have had law degrees, had no law education at all. They've had other kinds of education. A lot of them have degrees in other areas. If you want to become a Supreme Court judge, you got to go to Harvard, Yale, or Columbia, it seems like. That's 38 of them are from those 3 schools. There are very few from public schools who have been appointed to the Supreme Court. There are some. Now, it also helps to be from New York, or Ohio, or Massachusetts, it seems, to be appointed to the Supreme Court. The judges get appointed to the courts, as I mentioned before, and there's basically a few things that go into the politics of how they're appointed. As I mentioned before, that for district and appellate court appointments, there's generally, the president is expected to ask the senators from those states to give him a list of names. That is the blue slip, which is a list of people that are acceptable or not acceptable to them for the appointment. And generally, presidents have been willing to follow those suggestions. Not always, but usually they follow those appointments. There's also something called the litmus test. And this is a notion that presidents choose Supreme Court justices in particular based on their politics. How do they decide this? They give them what's called the litmus test. That is, they will sometimes ask Supreme Court justices, how would you decide if you had a case about abortion rights? Would you vote to outlaw abortion, or would you vote to make abortion legal, keep abortion legal? That's a pretty bold thing to do for a president. And a lot of people who are considered for cases or for seats on the Supreme Court will simply refuse to answer those cases. They will say, I'm not going to be bound by this. I'm not going to do your bidding. I will hear each case and I will decide according to what I think are the constitutional precedents and the merits of the case. But presidents always want to know that they're appointing people that will cement their legacy, right? So liberal presidents tend to want liberal judges. Conservative presidents tend to want conservative judges. Now, they have to go through approval by the Senate. And there's a whole nother politics of confirmation here, because a Supreme Court appointment is a huge deal. It's appointment for life, and the Supreme Court shapes everything about this country, shapes our lives down to the minutest details of what we can and can't do in all kinds of areas. And so these are very important appointments. And it means that a lot of interest groups get involved. A lot of people are involved in these kind of things. One of the things that happens is that think tanks, liberal or conservative think tanks, will come up with various suggestions they have of people who they think are suitable or would be good for choices at the district, appellate, and Supreme Court levels. And they will give these to presidents as they come into office, and they'll say, okay, you're going to be appointing these judges, because basically all presidents appoint at the district and appellate level, because people retire, they resign, they leave office, they do whatever they want to do. They move up to the Supreme Court, and so that to be replaced, run for Congress, various kind of stuff like that. And so there's always appointments to be made. Donald Trump appointed more federal judges than any other president in history, interestingly. There's a coincidence that lots of people happen to retire during his 4 years in office. Well, that means then that the nominee has to go through a background check. The FBI is supposed to do a background check on them to see about criminal records or criminal activities. They are supposed to listen to any kinds of complaints there have been. For instance, against the recent nominee Brett Kavanaugh, there were various complaints about sexual harassment and rape in the past. And the FBI is supposed to investigate those, meet with witnesses, collect information, and then present a report to the Senate about these. It turns out, we found out later in reporting that's been done more recently, that the FBI really didn't investigate those claims at all. And gave Kavanaugh a pass on figuring out whether he had been guilty of harassment or rape. These could be considered crimes that would make him unsuitable for Supreme Court justice. They could actually get him arrested and put on trial. So how could he become a Supreme Court justice with those kind of things behind him? So anyway, the politics are such that something like that may or may not affect a Supreme Court nominee's chances of success. Back in the 1980s, there was a person who was nominated named Robert Bork. Bork was a law professor. He'd been at Harvard for a long time. He was a conservative professor. He had some radical views on a number of things. He was sort of a libertarian in his views, and he had various kinds of ideas that a lot of people found offensive. And he came to his Senate hearing, and senators, it was controlled by the Democrats at the time, had a hearing in which they drilled him down to a very deep level, basically on his views on things, asking him, how would you vote on these kinds of things? What do you say? You said this in an article you published. You said this in your courses. What do you mean by that? And asking him to explain himself. He eventually decided to withdraw his nomination. He said, I don't want to go through this anymore. I don't want to be a Supreme Court justice. And he withdrew his nomination and was not appointed. Another thing that comes about with appointments is this notion that there are judges two types of judges, basically. There are strict constructivists and there are activists. Judges sometimes will say they're one or the other. Oftentimes they will say they're neither of those, even though the evidence suggests otherwise. Strict constructivists tend to be judges who try to stick to the strict letter of the Constitution. That is, they don't try to reinterpret the Constitution according to modern or contemporary issues. So they will look back to the Constitution and what it said in the late 18th century, and they will say, this is what the founding fathers intended by this wording. This is why I will decide this way on a case. Others take a more activist approach. That is, they say, times change. The Constitution is 250 years old. It doesn't have all these kind of things. It doesn't say anything about abortion rights. It doesn't say anything about civil rights. It doesn't say anything about same-sex marriage. How are we to know what the founding fathers would have said about those kind of things? Are we to say, yes, Jefferson would have been in favor of all these things? Or are we to say that Madison would have been opposed to them? Oh, we don't know. They're not around. And so we have to interpret the Constitution according to modern standards and modern beliefs and modern notions about how people live. Supreme Court justices ideally, I suppose, are immune from public pressure. That is, they are 9 people sitting there locked up in the Supreme Court building where they hear cases which up until very recently have never even been televised. They may be televised going forward because of the pandemic. But the idea is that these 9 people sit there and they hear these arguments, and that's what they base their decisions on, is the arguments put before them, the materials that their assistants have found for them, the research has been done by their clerks, and those kind of things. Then they make their decisions, and the 9 get together to talk about it, and they make a decision free of any kind of outside influence or politics. This is not the case. They do have political views, and sometimes they make their political views more clear than others. Sometimes they will decide things according to their political views. Sometimes they will choose cases to hear based on their political views. And so they know that people are outside, and there are important cases such as abortion rights or the election financing, and they get thousands of people standing outside the Supreme Court protesting. You get them from all sides protesting out there, and they can hear them from inside the building, and they know what's going on. They can watch the news, they see what's happening. They have a sense of what the public opinion is. And so sometimes judges will be swayed by public opinion. Sometimes they're even swayed by foreign policy of the United States. That is, in the Cold War, there were decisions made that reflected a sense of what the United States had to stand for in the world versus what was necessarily in the Constitution. All right. What do judges do all day, actually? They sit around and they make decisions about cases. As I mentioned before, they hear about 100 cases each year. There are about 7,000 petitions that come to the Supreme Court each year on a variety of cases. The Supreme Court has to decide that the Chief Justice ultimately is responsible for this. And what the Chief Justice tends to do is he tends to give cases that come from each of the appellate districts to certain judges. So each judge has kind of a responsibility for appellate districts. There are 13 districts, but only 9 judges. The reason why there are 9 is because there used to be 9 appellate districts in the federal system. And so there was a Supreme Court justice for each of the appeals courts. The appeals courts increased to 13, but the number of people on the Supreme Court wasn't increased at the time that happened. So we got 9. So each one has responsibility for sort of 1.5 appellate districts, and they will look at the cases, and then they will make recommendations to the Chief Justice. The Chief Justice will oftentimes share these with all the Supreme Court justices and have a vote. Do we want to hear this case? Do we not? This Chief Justice can decide all by himself whether he wants to hear a case or not, or he can ask other people to be involved in the decision. However, it's his decision. Well, the basic thing they're doing is what's called judicial review. That is, they are looking at court cases that have been decided already by courts, by the, as I mentioned before, the district, the appellate courts, or the state courts, those kind of things. And the idea here is that judicial review is the process whereby the judicial branch exercises its checks and balances against the executive and the legislative branches. So the Supreme Court can decide to hear cases. For instance, when Donald Trump first came into office, he signed an executive order preventing people from coming into the United States from there's 9 Muslim majority countries. and people sued, saying that that was a violation of the Constitution and the guarantee of equal rights. And it went to various courts. It went to district courts, appellate courts, and then up to the Supreme Court. The Supreme Court then has the decision to make about whether the president's action is constitutional or violates the Constitution. Right now, there are cases winding their way through the federal district about Donald Trump's turning over his records when he was president about the January 6th riot or insurrection. He's saying that he has executive privilege. The court cases so far have said, no, he doesn't have executive privilege because he's not the executive. And so therefore has no guarantee of privilege anymore. But those will maybe end up in the Supreme Court, which will then decide are this constitutional or not. Okay. The three kinds of things they can decide here. Certiorari is Latin for made more certain. That's basically what the Supreme Court does. And now you can oftentimes get two or more circuit courts that have ruled on a case. Maybe it's a similar case, generally, not the same case, generally, but they may be the same case. You may have a district court decide one way and appellate court decide opposite, in which case then you've got a conflict. And so the Supreme Court is then there to make everything more certain by being the final court of appeals that it can decide on all these kind of things. And once it decides, there's no appeal to any other court. In order to make their decisions, the Supreme Court gets various kind of things. First of all, you have to have standing. That is, you have to demonstrate that a court case that you've brought to this federal court affects you as a person or your business specifically. So you can't sue because, for instance, you couldn't open a lawsuit against Donald Trump saying that he didn't cut my taxes enough, unless you can prove that you have the standing. That is, you have the position in which this did affect you in some way that you claim, and that you are the only one that has the right to make this suit. Once the case has been accepted, then people can issue what are called briefs. That is, a brief is a summary of the court case. These are prepared by a number of different groups of people here. That is, each of the Supreme Court justices has clerks who work for him or her, and those clerks are lawyers in their own right, oftentimes have JD, PhDs, all kinds of things. They may have even been judges of some sort at one point in their career. Now they're working as clerks on the Supreme Court. It's a pretty big deal. And they do all the research that's necessary to find out what are the precedences, what other decisions have been made, what similar cases are there, all kinds of things like that. And then they write it all down into a summary of, depending on the judge, how long they want their summary. It could be 1 page, could be 100 pages, whatever kind of thing, something like that. And these are the briefs that tell each Supreme Court justice sort of what are the precedents, what other courts have decided, what they suggest perhaps that this judge should vote on that case. There are also things called amicus briefs, which are friend of the court. Amicus briefs are generally briefs that claim to be either neutral or supporting the one side of the case there that's come before the Supreme Court. The court then hears the case. Now, the way they do it is they read all the documents, and then they have lawyers for each side come to the Supreme Court building. They come into the Supreme Court where the judges are all sitting there across a bench, and all 9 of them lined up there. And each legal representative, a lawyer generally, has 15 minutes to present their argument. And the way it's set up is that the microphones are on a timer. And they have to talk into a microphone for 15 minutes. And if they're still going at 15 minutes, the microphone just shuts up. And that's the end of their argument. And so it's very important for these lawyers to be very brief, concise, direct to the point about what they're talking about, because 15 minutes is all they have. And then the other side gets their 15 minutes, and that's it. They go off. The Supreme Court justices then do their deliberations, and they announce their decision. Sometimes they'll announce decisions within a matter of hours or days, if it's an emergency kind of situation. Sometimes they will take months. So oftentimes they can hear a case, say in October, and then not announce a decision on it until July, which means they're doing their research, or they may be fighting or arguing over it, or they may put it aside and wait and get to it later. They can issue different kinds of opinions. Per curiam means a cursory opinion. What this is basically is they say yes or no, and they offer no explanation of their decision. And then there are opinions of the court. Opinion of the court means basically that everybody agrees and that this is the argument they're making. This is why they decided how they did. This is their opinion. So they have the option of saying why they made the decision, how they made it, what convinced them, kind of things. There can be a concurring opinion and dissenting opinions. Generally what happens is that the Chief Justice will have one of the other justices, associate justices, they're called, write the opinion for the majority. So if it's a vote, say 4-5, then one of the judges on the 5, a majority will write the opinion. And they will say, this is why the majority found the way they did. The other 4 can then write dissenting opinions. Each of them can write their own dissenting opinion, or they can write one opinion. So you can have one majority opinion, one minority opinion. You could have the opinion of the majority, but then each of the majority judges can also write a concurring opinion, their own view on the case in addition, and then you can have a dissenting opinion, or you can have a bunch of dissenting opinions. So you potentially have 9 different opinions coming out of the court. Generally, it's not that many. Generally, it's located, it's more like 2, a concurring and dissenting opinion kind of a thing. Or the court can simply say, stare decisis, that is, let it stand. And they can make the decision, whatever the case was decided by the appellate court, that's what the Supreme Court supports. They're not going to change anything. They just let the case go as the appeals court decided and presented at the Supreme Court. Okay, well, that's what I've got. Thank you very much for coming today. Let me know if you have any questions. I'm around on Tuesdays, of course, and we can meet anytime. If you just let me know when it's a good time for you to meet on Zoom, I'll be happy to meet with you. Well, take care. Good luck with everything, and I will see you later.